Morning, March 25th, and we're going to start with taking a look at an amendment to S9. So if Michelle, if you can join us and walk us through, which seems to be largely a technical amendment, but I'll leave that characterization to you, I guess.
Good afternoon. Pleasure to see everybody today. Hope you had a nice weekend. So for the record, Michelle Childs, Office of Legislative Counsel, and we are indeed taking up an amendment to S9. It should be draft 1.2. Did it as a strike all, doesn't need to be as a strike all, but just for context, and the underlying bill is pretty short. So the new sections that are being added to this are sections 1 and 2, and the chair is correct. They really are just technical. If you look at section 1, this is an amendment. Remember, we're working in Title 12. We're working in the civil protection orders related to stalking and sexual assault. The underlying bill is creating a process for the court administrator to establish after-hours court access for just the sexual assault orders, not for stalking. And that doesn't change. Nothing's changed in the underlying bill. But in section 1, you'll see that on page 1, line 12, so there's existing language in another section in that subchapter having to do, saying you'll see on line 12 that the complaints are to be filed during regular court hours. And I've just added some languages that says stalking complaints are to be filed during regular hours, because in another section you have the new procedure for the after hours access for the orders against sexual assault. And then page 2, section 2. This is something that is actually a miscellaneous bill, miscellaneous judiciary bill that you have. And it is truing up the language in this subchapter having to do with service and procedure. You'll see the language that's struck on line 7 through 9 about notification of the defendant, and it's just that the addition of the language that the clerk shall mail a copy of the order to the defendant at the defendant's last known address. That is the language that you have in the protection orders for domestic abuse in Title 15. And I honestly don't know the whole origination of why this, but I think they just want to make them parallel with how they're doing the relief from abuse orders in Title 15. And you can get an okay from George Zone, but I think also your sponsor of this bill knows about it as well.
Yeah. Mail is considered served, right?
Yes. Mm-hmm.
Yeah, I think the change that occurred is just if the defendant is in court and understands the order, that's actually having the service with them as access to mail, and that's what we had in the other RFA, and the same here.
Mm-hmm. And so then sections 3 and 4 are exactly the same as the bill is introduced. I just included them to put them all together for the floor section.
Any questions on this amendment?
Yeah, maybe it's been said in the past on the stalking complaints being filed just during regular court hours. Was it ever discussed to ban that?
They did, and I think the witness testimony from some of the survivor organizations was that at this time they weren't requesting to go to that stage. The difference is that, and I don't remember the exact numbers, but there are over 1,000 orders against stalking that are filed. And while stalking is a very serious offense, sometimes it can be disagreements between neighbors and things like that. And there's a lot more for the court to kind of sort through. And so I think in discussions between the survivor organizations and the court, they decided this would be a good first step, is to focus on the orders against sexual assault. Mm-hmm.
And I did reach out to the network. It has received an email back that they were fine with this. So I don't expect that we're going to need additional testimony. I also reached out to Judge Zone, and he emailed back that he actually suggested language for that first section. So I think unless folks have other ideas, I don't know that there's additional witnesses that we need for this one. So any other questions, Michelle? Not seeing any. Right, thank you so very much. Thank you. Thank you. So what is your timing, Mike? Because I thought that you were only available at 2:30. This says things shifted.
On 2 until 2:30.
You're available from 2 until 3. Well, welcome to the chair then, because I have a feeling that this walkthrough might take a good part of that. So let me. So we'll pass out the bill and you just give us a moment.
Can I share the screen?
Yeah, if you join the Zoom meeting, I'll do my
Okay.
clicking over on the screen.
Just a moment. Thank you very much, sir. Thank you. Yeah. Yeah, just trying to keep it. Thank you.
Thank you very much. I hear you in class.
Yeah.
Yeah.
We started it up.
That's me.
Yeah.
It's
Is it part of the you also? Oh, yeah, it's a. I mean, you could literally or figuratively. It's great. Nice. Sorry. As you can imagine. It's fun. Yeah. You're all set.
You can say that again.
Okay, should I begin?
Please, over to you.
This is Mike O'Grady, with the Office of Legislative Counsel. I'm here to walk you through S-45 and Act relating to protection from nuisance suits for agricultural activities. So before I get into the bill, I want to talk about the context of why the bill was introduced and why it's been introduced pretty much over the past 4 to 5 years. And it's because there's been anxiety in the farm community about lawsuits and specifically nuisance suits. And when the farm community looks at how other states are addressing this issue, Vermont is on one end of the spectrum. And I say that objectively because a few years ago, one of the ag committees asked me to put together all the states' right to farm laws and to look at them and to kind of objectively assess where Vermont fell on the spectrum. And just to give you some examples, so starting out with Vermont, Vermont gives a rebuttable presumption that an activity does not constitute a nuisance. Ag activity meets all the following. You have to show all of these 4 criteria. It's conducted in conformity with federal and state local laws. is consistent with good agricultural practices, but good agricultural practices is not defined. It is established prior to surrounding non-agricultural activities, and it has not significantly changed since the commencement of the prior surrounding non-agricultural activity. If you prove all those four, you get a rebuttable presumption that you're not a nuisance. But that presumption can be overcome to be rebutted by showing the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the use and enjoyment of the neighboring property. So even if you prove all four things and get nuisance protection, the plaintiff can still overcome that nuisance protection by showing one of two standards. And then nothing in the section construes or should limit the authority of state or local boards to abate nuisances affecting public health. So even if you qualify for the private nuisance protection, you could still be subject to public nuisance enforcement. So that's Vermont. I'm going to show you three examples, starting with a bill that's basically the basis of S45, and then ending with one that is my favorite, but probably won't be your favorite. So there's Kentucky, and it just says no agricultural, silviculture operation. And so many of the right to farm bills are also right to forestry bills. So no ag or silviculture operation shall be or become a nuisance or trespass. So it's not just nuisance and trespass, private or public, or be in violation of any zoning ordinance or be subject to any ordinance that would restrict the right of the operator of the ag or silviculture operation to utilize normal and accepted practices by any change condition in or about the locality thereof after that time. And the provisions of the subsection shall not apply whenever a nuisance, trespass, or zoning violation results from negligent operation of an agricultural silviculture operation. And then an agricultural silvicultural operation shall not lose its status by reason of a change of ownership or a cessation of operation of no more than 5 years or 1 year after the expiration of a state or national program contract. So you are just not a nuisance if you were operating for 1 year prior to the surrounding activity and you weren't a nuisance at the time of the initial operation, and you also get protections from trespass, and you even get that if you cease operation for up to 5 years. And then Michigan, a farm or farm operation shall not be found to be public or private nuisance. Farm or farm operation alleged to be a nuisance conforms to generally accepted agricultural practices according to a policy determined by the Michigan Commission of Agriculture. So that is kind of similar to Vermont's law, but it's not a rebuttable presumption. It says you are not a nuisance if you conform to generally accepted agricultural practices that the Agency of Agriculture adopts. Farm or farm operation shall not be found to be a public or private nuisance if the farm or farm operation existed before a change in the land use or occupancy within 1 mile of the boundaries, and if before that change in land use or occupancy would not have been a nuisance. In addition, a farm or farm operation that is in conformance with subsection A, so it's complying with the ag practices, shall not be found to be a public or private nuisance as a result of any of the following: a change in ownership or size, temporary cessation or interruption of farming, enrollment in government programs, adoption of new technology, a change in the type of farm product being produced. So those are all significantly more protective of the farming activity than what you get as a rebuttable presumption in Vermont. But that is not nearly the most protective. The most nearly protective is Oregon. No farming or forest practice on land zoned for farm or forest use shall give rise to any private right of action or claim for release based on nuisance or trespass. This shall not apply to a right of action or claim for relief for damage to commercial agricultural products or death or serious physical injury. In Oregon, you get protected from nuisance or trespass if you are just on that zoned land, even up until you kill or seriously injure someone. And that case, that law has played out. It played out in a situation, again, it's a forestry and farm protection, where a forestry operation was aerial applying pesticides by helicopter, and they sprayed a residential subdivision. And the court said that they were protected from nuisance or trespass in that situation. They were spraying land that was zoned for forest use. So that is kind of the spectrum that you're on.
The subdivision was zoned for,
Subdivision was partly on land that was zoned for forest use. And so what does HS 3045 do? So turning to the bill, the first thing to look at is the legislative findings and purpose section, which aren't changing, but it reflects what this entire chapter was entitled to do. It does create a chapter in Title 12, the court procedure chapter. It goes on to say that in order for the ag industry to survive in the state, farms will likely change, adopt new technologies, and diversify into new products, which may mean increasing size. And the General Assembly finds that ag activities are potentially subject to lawsuits based on the theory of nuisance, and that these suits encourage and could force the premature removal of farmlands and other farm resources from ag use. Therefore, it is the purpose of the chapter to protect reasonable agricultural activities conducted on the farm from nuisance lawsuits. But that's not really what Vermont's law does right now. It just gives the rebuttable presumption. It doesn't prevent a nuisance lawsuit like some of the laws in other states. It just shifts the standard. So it's not protecting a farm from a nuisance lawsuit. So then you move into the changes in S45. There's a change to the definition of agricultural activity. Really, it's just restructuring this definition to reference the fact that there's going to be a new definition of generally accepted agricultural practices on page 3. And these are going to be compliance with the water quality requirements for farms in 6 VSA Chapter 215, including the RAPs, compliance with the Agency of Ag pesticide rules, and then practices conducted in a manner consistent with proper and accepted customs and standards followed by similar operators of agricultural activities in the state. So remember, Michigan had that. If you follow the generally accepted standards that were set by the Commission on Agriculture, then you would get that protection. This doesn't say that the standards are set by the Agency of Agriculture. So it would become something of a fact-based review in a court about whether or not the practices that are being challenged are good agricultural practices or accepted customs and standards. But it is consistent with the standard that is used in many other states. And then you come to 6 BSA 5733, which is.
Before you get to that, just a quick question. As far as the practices, the generally accepted agricultural practices, can that be defined to include like the on-farm activities, on-farm, where people are like on agriculture tourism, I guess, is that what it's called? Where
Sure. So
folks are invited onto the farm to view, to have a tour, to see the maple leaf, the sugaring operation, et cetera. Is that?
one of the things I skipped over is language in the definition of agricultural activity that is not changing. And that includes the definition of farming as defined in 10 VSA 6001. And that's the default definition of farming. It's used in Act 250. It is the standard or basis of the standard for how farming is defined under the RAPs. But the other definition there, what is an agricultural activity? as defined in 6 VSA 4802. It includes a long list of activities, which includes things like farm labor, farm housing, composting of material, handling of livestock and waste, operation of farm machinery and equipment. So it doesn't include farm tourism, but it does include a broad array of activities that go beyond what some people might think are the traditional definition of farm.
Thanks.
May I ask a
Yeah, go ahead, Angela.
question? I think I just heard you say, Mike, that the way this is worded, practice was conducted in a manner consistent with proper and accepted customs and standards without identifying who sets that standard. That is common phrasing.
Yes, consistent with proper and accepted customs and standards or something very similar to that. It's in the various states. It is pretty common, yes.
Okay, so it's understood who would be looked to determine
So-
accepted customs?
So part of it is, and part of why it's left a little vague. Farming practices change from state to state. They vary from state to state. You can't say what's a generally accepted standard in Iowa is the same as it is in Vermont. Because there are different standards in those states. Iowa is largely an industrial farming state. What is authorized and allowed is very different from what is allowed and allowed. So it will, as the language is drafted now, be a fact-specific review by a court. You will have experts that will continue to come in and provide testimony about whether the practice is one that's consistent and proper with accepted customs and standards.
Okay, I'm just thinking expert testimony, expert witnesses are usually quite expensive and it adds time.
Yes, and there's a provision later in the bill that is intended to try to forestall actual litigation, to try to reach a resolution prior to the litigation, and I'll get to that in a second.
Thanks.
So instead of all of the language about a rebuttable presumption or the 4 factors or criteria that a farmer needs to show in order to qualify for the presumption, instead of giving the plaintiff the opportunity to overcome that presumption by showing one of 2 standards, on page 4, you'll see that the standard has been changed to no agricultural activity shall be or become a nuisance or trespass when the activity is conducted in accordance with generally accepted agricultural practices. So if you're complying with your RAPs, complying with the Agency of Ag rules on pesticides, and you are implementing generally accepted customs and standards for that practice, then you will not be subject to a nuisance or trespass suit. But a plaintiff alleging that an ag activity is a nuisance or trespass shall have the burden of proving by preponderance of an evidence that the ag activity is not conducted in accordance with generally agricultural practices. When you look at some of these cases as they played out, the farmer has had to basically assert themselves and prove that they meet the generally accepted standards, that they meet the RAPs, when it's really the plaintiff should be showing that the farmer is not meeting those. And this is something that I think is important to some of the farmer advocates out there, that they're being sued, but they should, as a tort, the plaintiff should have the burden.
If one other farmer in the state is practicing a generally accepted agricultural practice, does that cover it?
I think that will depend on testimony. I think you will hear, if there was litigation, there would be testimony from, say, UVM Extension. What they oversee and they provide guidance for a lot of farming practices for many farms in the state. You could talk to the Agency of Agriculture, what is permitted under a large farm permit or a medium farm permit or a required ag practice. You could talk to seed consultants or some of the agricultural consultants out there, the Minor Institute. There's a plethora of experts that could provide input on whether or not it was a generally accepted practice.
What if all those witnesses, then it wasn't considered a generally accepted practice, 10 or 15 farms in the state doing it?
And if the court found that it wasn't consistent with proper and accepted customs and standards, then the farm would not receive that.
You would? Ian?
No, but that's all the answer.
Yes.
Just while we're on that, was there discussion in the Senate about using the language from the Michigan law to have the generally accepted agricultural practices defined?
You could do that. It's definitely something that Michigan and other states do, having an entity define what they are or providing guidance on what they are. I think that that's an option.
Is there any, and just one other, is that term utilized at all in Vermont statute currently?
So it's already in the right to farm, where the farmer has to show that they are consistent with good agricultural practices. But that is not defined in the current right to farm law.
Is there like a lot of case law around defining it that people could look to?
There's not a ton of case law. There are cases, Tricketts versus Ox, another recent case, but there isn't a wealth of cases. Moving on from there, there is a provision that says the nuisance and trespass protection from an agricultural activity shall not apply whenever a nuisance or trespass violation results from the negligent operation of an agricultural activity. So if the ag activity can be shown to have been negligent, it would not qualify for the protection. And then 5754 is a directive that courts liberally construe the protection in order to effectuate the purposes of the chapter. And the ag activity shall not lose the nuisance or trespass protection due to a change in ownership, change of crops, change of farming method, including technology changes.
So back on page 4, the language under subsection A, is that seems uncommon. I don't recall having seen that kind of language.
You might think it's uncommon, but it's actually in statute more than you would think.
Haven't seen it.
It is there. And I can provide you a few other examples.
Do we ever say that it should be liberal or conservatively construed?
No.
Is it assumed that that's the way it should be construed if we don't say it's liberally construed?
Well, I mean, if you want your intent to be known,
Political, not being.
No, I know you're not, but that's.
if you want your intent to be known by the courts, I think that's why these statements are included.
So what's the default intent? Is kind of what I meant by that question.
Well, I mean, courts start with statutory construction principles. They presume everything is constitutional. They look to affect the intent of the legislature. They will look at multiple tools in doing so.
I guess that was a question for Zone A as well, just because it's kind of interesting language, because if you just construe it as they normally construe things, but.
I'll show you I can find a few examples once I get back to my office.
Okay, thanks.
So then you come to that provision that I referenced in response to Representative Arsenault's question. There is a provision that will require any person before they file a nuisance claim or trespass claim arising from an agricultural activity to at least once attempt to resolve through mediation the issue or dispute that the person has concerning the ag activity. It doesn't require them to reach a remedy. They just have to try and implement mediation one time. And then the parties may agree upon the use of the mediator. They may agree not to resolve the dispute through mediation and go to arbitration, but again, that's voluntary. And then on page 6, if they can't agree to mediation, the person bringing the court action based on claim or of nuisance or trespass shall provide the court with a sworn statement, an intent to resolve the issue or dispute through mediation. The mediation is conducted according to the state's Uniform Mediation Act. That act does not specifically address cost, and this language does not specifically address cost either. The concept is it would be shared, but there needs to be that sworn statement that they have attempted mediation and it was not successful.
I'm fascinated by this provision. Is this something that is, in other statutes, this requirement?
Not in Vermont, but there is I can't remember which state it's in, but it's in another right to farm law in another state.
And it doesn't appear anywhere else in Vermont statutes or?
Not that I am aware of.
Yeah.
Well, actually, there's isn't the bankruptcy law now based on some form of mediation? Have to look into that.
I'd also wonder what the court rules are for mediation, because I know a lot of mediation does occur. I'm wondering how often it's court ordered under court rules as opposed to legislation.
Like in a civil case?
Yeah.
Yeah, like in, yeah, that you.
Or family case.
Yeah.
Yeah, it's so interesting. I've never seen it. A lot before.
As I said, it's not common in Vermont, but it is used in the right to farm statute in the state. And so that's the bill. I'm sure you're going to hear from both sides, as you have over the past 5 years, every time the bill has come up.
I don't think we've dealt with it so much in here. It started, didn't we? Rings a bell, but I don't think it was a bunch of testimony. See. All right, well, thank you. Any other questions for?
I'd like to know the vote coming out of Senate Judiciary.
For one.
Yeah, it was 4-1. And then on the floor, it was 25-5.
Okay. Yeah, Angela.
I do have one more question about this required mediation, and you mentioned that the Uniform Mediation Act does not address costs, and the idea is that it would be split. Would it be legal to actually say that it has to be split between the costs shall be borne evenly or something? I just worry about setting people up to then like fight over who's gonna pay for the mediation and.
Well, I can look at the other mediation provisions to say if they say that, but the family court provision, I don't think it says anything about costs in that provision. But I can look at other examples.
Thank you.
All right, any other questions for Mike? All right, thank you for finding time in your busy calendar
About that.
for this stuff.
Good.
Thank you.
We'll give you 9 minutes to yourself, Mike.
Yeah, you can take a break, take a breath.
I could go walk through 7 bills in the next hour and a half.
It's so afternoon, huh?
So we'll turn to Oliver Manning next, if Oliver Manning is here, because I don't, there we are on the screen.
I'm here.
Yeah, over to you. If you could identify yourself for the record and proceed with your testimony. Thank you for being here.
Okay, yep. My name is Oliver Manning. Good afternoon, and thank you for the opportunity to speak on behalf of Vermont dairy farmers. As many of you know, Vermont farmers are world renowned for their strong agricultural brands, from Cabot cheese, maple syrup, McQuam wines, boneyard vegetables, and cobbled knoll orchard apples. Me personally, I'm a 4th generation farmer in Swanton. I, along with my father and brother, operate a medium-sized dairy farm, milking approximately 550 cows and growing crops on about 1,000 acres. Our farm is located in close proximity to the city of St. Albans, Interstate 89, and Swanton's designated Southern Growth District. Outside of farming, I am also a member of the Swanton Planning Commission. Over the last 2 years, this commission has been rewriting the zoning bylaws for our town with the goal of making our regulations more closely aligned with new laws from the state and streamline development processes to encourage growth and to meet the constant demand for new housing. Throughout this process, it has become very apparent the need for new residential growth, not only in our town, but in all of Vermont. With growth, there can be challenges. While I fully support our town and our governor's goals to make more housing, I am cautious of the burden this may put on our Vermont farms. Farmers are the backbone of Vermont. From the small fruit and vegetable farms on a small homestead to the large modern dairy and maple farms covering thousands of acres, all farms provide enormous value to our state, economically and nutritionally. As we saw during the COVID-19 pandemic, a global food chain cannot always be trusted to provide for the masses. I feel here in Vermont, we are blessed with a great variety of farms, providing necessary proteins and vegetables to our local people. To bring us back to why we are here today, I believe now is the time for our leaders in Montpelier to pass strong protections for our farmers' right to farm. Farmers face many challenges, from low commodity prices to high input costs and the threat of litigation for performing their daily work to provide food, fiber, or other products for our state. And they should not have to worry because a neighbor is not familiar with their way of life on the Vermont farm. Here in Swanton, recently a small strawberry farm had to spend tens of thousands of dollars to fight for the survival of their business because a neighbor was unhappy with their business. I first learned of this ongoing dispute at a development review board meeting and contacted the farmer for more information and to offer any resources or knowledge I had to help them. Through discussions, I learned that this farmer had done nothing wrong. All paperwork and licensing with the Department of Agriculture was up to date and accurate. All farm practices were followed, yet still they were in court. After a court ruled that there was nothing being done to warrant the case proceeding further in their jurisdiction, it was sent back to the Development Review Board, where the neighbor challenged that the vegetable farm was not a farm because only a small percentage of their total acreage was being used for farming. The DRB ruled that all necessary paperwork was shown that the state of Vermont considered them to be a farm and that the town had no standing for the case, and ruled that all permits were correct and could not be revoked. In my last discussion with the farm owner, they had been told the neighbor would be appealing this decision to environmental court, further costing this farm in lawyer fees and other legal costs. This farm made it very clear to me that if not for outside revenue from their construction business, their farm would have been forced to close years ago. This is just one example in our state where farmers are having to spend their time and money their time and money fighting for their survival in courts. As was stated in the last testimony on this bill, we farmers are not looking for the state to hold up bad actors unaccountable, but we are simply looking for protections that will streamline any litigation and to provide a quick to prove innocence and save our farms money and time. I feel that now is the appropriate time to provide these protections for our farmers because as more housing is developed in our communities, filling with people from out of state or more urban parts of our state, we cannot risk losing any more farms. A growing population is not the only reason to protect our farms. New tariffs and trade tensions between the United States and Canada are also a significant area of concern for our farmers and the economy. In the instance I mentioned before, the berry farm in Swanton, it is important to support these farms to keep a local option in place for Vermonters to get fresh, affordable products without having to spend more money by buying goods from Canada. In closing, I ask that you please work together, not as Democrats or Republicans, but as Vermonters to offer strong, sensible legislation to provide protection for agriculture in our state, to protect the way of life for so many Vermonters so that future generations of Vermonters can be as proud as I am to be a Vermont dairy farmer. Thank you.
Thank you very much, Oliver. Appreciate it. Angela.
Thank you for being here, Oliver, and please forgive my ignorance, but I'm curious what kind of complaint was being made in the case of the strawberry farm? Like what was the complaint and what was what was the nuisance charge?
So when I first heard about this, I assumed that it was some type of a pesticide issue. But when I spoke with the farmer, they couldn't tell me. They had never been, and they'd been in court for years. The only challenge that they'd had was just that the neighbor said they're not a farm because they owned 15 acres and they only farm on about 1.5 acres. They're just starting and growing. And they are in a mixed use residential agriculture area. The neighbor really isn't that close by. There was never any clear and at the DRB meeting, the only complaint that was filed was that they weren't meeting the standard of the state of Vermont to be a farm, which they were, and the state agreed with them, the town agreed with them and ruled so, but now they're in court again because it's just some, a neighbor that has the means to spend money on lawyers and court fees because they don't want, I don't know if it's traffic or what exactly it was. It was just challenging whether or not they were a farm. In this instance, I would actually say, that the laws are working, but they've still been in court for over 3 years and have spent between $40,000 and $50,000 on lawyers. So while they haven't been put out of business, that if not for their other revenue, they probably would be.
Wow, thank you. I'm sorry to hear that. I mean, yeah, I just want to know a little bit. I'm curious to hear more stories about, obviously there's a need for the bill, but I'm not aware of them. So it's very helpful to hear.
Yep.
Stories.
Other questions for Oliver? Yeah, go ahead, Tom.
Yeah, Oliver, I'm just wondering, in your opinion, does this bill do what you think we need?
Yes, I think it does.
Thank you.
Anything else? All right, thank you so much for being here. I really appreciate your testimony. It's very helpful to hear the situations, like Angela said. All right, so we'll go to Gerard Borstevel. Did I say that right? And you're Claudine? Yes, Claudine Safford. Yes, it's fine. We can certainly change up the order. That's no problem. Identify yourself for the record and proceed. Thank you for being here.
Good afternoon. My name is Claudine Safar. I'm an attorney with the law firm of Monahan Safar in Burlington, Vermont. I represent the Roosevelt Farm, and I presented last time before the Senate Committee on the Judiciary. I don't know if anyone had the opportunity to review that testimony, and I don't want to be repetitive, but what I would like to do from a legal perspective, and then I'd like to sort of perhaps present my client so that he can tell you his story from a practical perspective about what happened to the Roosevelt Farm.
Before you start, it's okay to be repetitive.
I was just about to say.
Yeah, chances are,
You haven't heard it.
I haven't heard it, and chances are maybe somebody else hasn't either, so.
Fabulous.
Yeah.
So I will be repetitive.
Yeah.
I'm good at that as a lawyer. So why are we here? We are here, and you will probably hear from opponents of this bill that there is nothing to fix. This is what's told to the Senate committees. There's nothing to fix. Our law does a great job. It's perfectly adequate, and there's lots of reasons why it's perfectly adequate. We obviously disagree, and the farming community disagrees, otherwise we wouldn't be here today. The reasons that we disagree is looking first at taking a 30,000-foot overview and looking at the purpose of the right to farm bill. What is the purpose of this law in general? Purpose of this law is to, as has been identified already, protect farmers who are conducting reasonable agricultural activities from nuisance lawsuits, encourage improvements on farms, and to allow farms to change, diversify, and expand. And what does that mean to change? It means to progress. We don't want farming practices we can all universally agree that it's not always advantageous in any industry to stay with stable and static methodology that is found to be better in some other way. We want farming to progress in environmental ways, in productivity ways, and in lots of ways that they see prudent for their businesses, for their survival. And that's pretty multifaceted. And so when we look at our existing law, you have to ask the question, does it do that? Does it protect? Does it accomplish the interest, and does it protect farms? And I would submit to this committee that it absolutely does not do that at all. And the question is why? And I think you can answer that question by looking at the scheme. So first and foremost, this scheme sets up a rebuttable presumption. And that rebuttable presumption is available to farmers under that they are not a nuisance if they can satisfy 4 prongs. And so you have to take each one of those prongs individually. And if you cannot meet these 4 prongs, you are immediately disqualified from having this rebuttable presumption. So looking at prong 1, you are eligible for this rebuttable presumption if the activity is conducted in conformance with federal, state, local laws and regulations. And so you have to look at that individual prong and say, well, what federal, state, local laws and regulations? I don't really know. And as someone who has been dealing with this law and trying to manipulate this law through a legal process, I really don't know what this means. I'm not sure about which laws they're talking about being applicable. And in the Senate, I used the example of speeding, for example. If we set up a rebuttable presumption that I did not speed on my way here, how do I prove to the court? How do I prove a negative? Do I need to take a speed gun with me the whole way? Is it sufficient for me to tell you that I didn't speed on the way here? Well, the interesting thing in this particular case with my client is the court said it is not sufficient for you to show to the court that you haven't been cited for something. So if we go forward, we say, Judge, my client does not have any active complaints by the Agency of Agriculture. We are in conformance with all of our permits. She said, that's not good enough. That's not good enough. And so as an attorney and a representative representing a farm, I have to scratch my head and say, well, how do I prove to you that we're in conformance with all of the rules? With all of the wrap rules? That's a very exhaustive list. How do I prove to you I'm in conformance with those? And do I have to prove municipal laws? Well, gosh, I think we're exempt from municipal legislation. What do I have to prove there? I mean, there's a whole bunch of laws there. Do I have to prove all of those? And she said, that's just not enough, folks. The fact that there is an absence of regulatory action against you isn't good enough. Well, I guess there's just no way to satisfy that. We would be here forever if I went through every single law and proved to you. Now I got to bring in evidence, which is not just, it's not that I have to bring in experts. Do I have to bring in witnesses? Who do I have to bring in? What are my burdens? Well, how do I satisfy that burden? Where is the hurdle that I jump over, and how high is it? Because just the fact that we're not being cited by the very people who are there to control these regulations and to cite us if we're doing something wrong, the judge said that isn't enough. Well, gosh, I am perplexed. I guess there's just no way to get this rebuttable presumption. And I've only gotten to prong 1. I haven't gotten any further yet. Boy, okay, I guess now I can go on to prong 2. Is consistent with good agricultural practices. Well, what's good mean? I'm not really sure what's good. What's that mean? Now I'm confused on prong 2. But now I'll move on to prong 3. It is established prior to the surrounding non-agricultural activities. oh boy, what are surrounding non-agricultural activities? How far do those surroundings go? Is it just my immediate neighbors? Is it 2 houses over? Is it 4 houses over? One of the issues in this case that my client will tell you about is that the complaints in the case of the Borstveld farm included smell coming from their manure pits. And as good Vermonters, we know that we drive around and we smell cow poop. But in our case, the court ruled that my client's cow poop was particularly noxious. So it was a very special sort of cow poop that smelled really, really bad. I guess I don't really understand that, but with all due respect to the court, it was somehow special cow poop that smelled worse than other cow poop. Still cow poop, but cow poop sort of, it smells and it travels. How far does it travel? How far do these surrounding non-agricultural activities go? Are we going 4 houses down? Are we going 6 houses down? I really don't know. The law doesn't tell us. So the farm has to be established prior to, well, there's a house that just popped up 6 houses down and they don't like the smell. So I guess we are not going to receive the benefit of the rebuttable presumption. But in any event, this law doesn't tell us how far this projects out. So I would submit to you yet another prong that is completely confusing and inefficient and really doesn't accomplish its goal because it doesn't actually help the farmer at all. And now we're on the final prong. The activity, it has not significantly changed in the commencement of prior surrounding non-agricultural activity. So in our case, our clients built another manure pit and they installed tile drainage. And so these are what arguably are forward practices. Our Agency of Agriculture asks that our farmers have a sufficient storage for our manure because they want to make sure that they're applying during certain times of the year so that if depending on how they're applying, surface applying or whether they're manure injecting, that we don't end up with manure that's, kind of being applied at the wrong time of year and then it ends up in our water sources and whatnot. So we have regulations for these things. They have to comply with them. And as a result, they have to have a sufficient amount of manure storage. So if you build another manure pit, now you've changed something. And the court has said these are significant changes, among other things. So, there we're out again. So we did things that were either progressive or according to the rules, and we no longer are the beneficiaries of the rebuttable presumption. So, that asks another question, which is, don't we want our farmers to be doing things that our agencies ask them to do? And don't we want them to be changing, particularly if these changes are new and positive things and innovative things that they need to be doing to stay with modern farming practices? So I've gone through 4 prongs that are necessities in order to get the benefit of this rebuttable presumption, and we found errors in all 4 of them. So effectively, there's just no way to get the benefit of this rebuttable presumption if you're a farm. I don't know how to do it. It's just wholly ineffective. It doesn't work at all. And the law really, really, really needs to be changed. That's why we're here. Looking at the changes, you may hear, well, this goes a step too far. It not only protects farmers from nuisance suits, but it also protects them from trespass. And this is just going a bit too far. So we definitely don't want to do that. Please don't do this. Take out the trespass. Gosh, if you're going to do anything, protect them from nuisance, but don't protect them from trespass. Well, that really is only kind of half the battle, because if we're looking at, for the example of smell and water coming from tile drainage, these things can also be considered a trespass because it is water being discharged in our circumstance back into conveyances where the water naturally flowed anyway, going through town culverts and flowing where it flowed before. But that was not only deemed to be a nuisance, it was also deemed to be a trespass. That's kind of the physical invasion onto somebody else's land versus the annoyance piece of things. But I would submit that you sort of have to address both. You can't leave it on one side and not the other. This law does a good job of recognizing that. Smell can also be considered a trespass. That was one of the actions that was brought in this particular case. And so we really applaud the fact that they have considered trespass as well as nuisance. It's really, really important. It's an important part of this law. We would ask that you not dispense with that because it's only doing half the job that it's supposed to do. And it wouldn't really protect the farmers in totality. So I think that these changes are obviously really, really important because the law that's on the books now is wholly ineffective. It's wholly ineffective to protect farmers and do the job that the purpose of this legislation is there to do in the first place. And we think that this has done a pretty good job of addressing these issues. It's done a good job of sort of also shifting that burden, which was just recently discussed, that it sort of puts the burden on the person that is trying to bring the complaint as opposed to putting the burden on the farmer in the first place. So at this time, I guess I would like to address any questions that you might have, and I would cede the rest of my time to my client to tell you a little bit about what happened in his case. I will say that, one sort of important point that happened in our presentation before the Senate committee is there was a video that was brought by the neighbor. And they said, gosh, we really want to show you the water that was kind of flowing onto my client's property and why this is so important that we preserve this opportunity to bring these nuisance lawsuits. One really important thing to understand is that part of the videos that were shown, the town of Panton has lots of dirt roads. And much of the water in the case that was being shown in these videos is coming down town ditches from town roads. And so all that was shown was the water that's flowing across her client's property, but it was never explained that the bulk of this water comes from town ditches and town roads. So it looks very impressive when you see a video, but when you're not sort of understanding the totality of the circumstances and seeing in the July 10th storm, which these videos were presented on a storm event that took Vermonters' lives, it took Vermonters' property, it devastated people. But we're going to show you a video clip from one of the biggest storms that we've had in our lifetimes, and we're going to tell you that this is what it looks like on a daily basis, which is just not accurate. It was, I have to acknowledge, a wonderful effort at spin, but it's just simply not reality. And in fact, it didn't accomplish what it needed to accomplish, but was very successful in the images that it conjured up for the courts and for many people that got a chance to see those videos. So I don't know if you have any questions for me about that particular case. I'm happy to answer them, or I'm happy to turn it over to my client to kind of tell you about what that litigation has done to the farm.
Yeah, let's open up for questions. Yeah.
Thank you very much for your testimony. Very helpful to go through it. I'm just curious for 57, 53, is there has this been litigated for is there any case law that exists that helps define any of these subsections that you utilized during your representation of your client?
Well, so I just want to be clear. I was not trial counsel in that case. So I was not there litigating on the pieces of the rebuttable presumption. But I think the answer is yes. But this particular analysis it's a factual analysis. It's heavily laden with factual determinations. And so that's, part of the problem is that the court was, in that case, was looking at, whether the farm, for example, had significantly changed. And that's really a factual determination, right?
I understand that.
Yeah.
But just, part of your criticism of this, which is fair, is the lack of clarity as to what is being defined. So if is case law that's helped to sort of define that, I'm just curious what it is.
I can't tell you that there is case law that would narrow this in any way that would be useful. Right. I cannot point you to a specific case that would answer some of these questions. And in this case, there now is case law that says, for example, that lack of enforcement does not show you that you're in conformity with these state local regulations. So now we do have case law, and with all due respect, it's terrible law because it sets up an impossibility to be able to take advantage of this rebuttable presumption.
Do you have that case?
So it is this particular case. Yeah, it's Airy Point versus Forestfeld Farm. I'm happy to provide that,
Yeah, if you
to
could.
you all if you want, that can show you that
Yeah.
trial court decision
Yeah.
that said that. We can highlight those.
Yeah, that'd be great if you could send that to Nate.
Yeah, absolutely.
Great, thank you.
Other questions? So I have a couple questions. So on page 4, line 7, 8, it's the striking of language, nothing in this section shall be construed to limit the authority of state or local boards of health to abate nuisances affecting the public health. Do you have any comment on that language being struck? It's a subsection B of 5753.
Well, so my firm does a lot of municipal law. We represent like somewhere in the ballpark of up to 35 municipalities in the state. So we do a lot of work for municipal boards. And I would say that striking this language kind of doesn't really matter, because I think health orders can be issued from municipalities anyway. Like if you have something that violates the health and safety of the public, then
So just not necessary.
yeah, it's unnecessary. I think you're going to have a health officer that if they have to bring a health complaint, they can do that anyway. But I think this is really an issue of like bringing a nuisance suit, and that's not a neighbor bringing a nuisance suit. That's a municipality whose health officer would have to be complying with municipal regulations that would say this is, you've got a health concern here. So I don't really know that. I guess my opinion would be, I don't think it's really necessary from a municipal perspective, and I don't think it sort of takes anything away.
All right, no,
I
that's
think those health officers are independently authorized anyhow.
fair enough. And before I get to Ian, just the other question I had was the required mediation. Any comments on that provision that we've added?
Yeah, that's an interesting thing. I mean, in all honesty, mandatory mediation provisions are, they're kind of interesting. If people want to mediate and they want to get together and come to a reasonable solution, they're going to do that. Sometimes my frank perspective is forced mediation when you have people that want to sue each other for nuisance, and we've gotten to this point. Sometimes it's a forced expenditure of funds, right? They're not necessarily going to get anywhere anyway because they disagree. But on the flip side, it is forcing people to sit at a table and to have a conversation that they may not otherwise be willing to have. And I think in my experience representing a lot of farms, my general experience with farmers is that these are all people that are not looking to upset their neighbors, and they're happy to work things out. And so if people are amenable to conversations, those conversations are generally happening anyway. I don't know that I don't think it's a bad thing to ask people to attend mediation. I think I'm a fan of mediation. I think mediation is great to be able to you ideally want to resolve your own disputes rather than heading to court. I'm not either for or against this. I think it cuts both ways, to be honest.
No, I appreciate it. Ian.
Are we kind of falling into the same trap of the ill-defined term of good agricultural practices in subsection A1B that would we be striking when we add in the language of generally accepted agricultural practices in the new proposed language?
So let me find where you are so that I can.
What page are you on?
The new language is on page 4, line 6. And the old language was in the struck language, one of the prongs, the prong B.
But don't you go back to the definition then on page 3, right? Is that where we should be looking?
I mean, wouldn't prong B also fall within the definition?
Good agriculture practices versus generally accepted.
And I think what I heard was, well, what's good agriculture practice? And I guess does the same criticism apply to what's generally acceptable agricultural practice?
Yeah, well, I think this has made efforts to try to define it, right? You've got A, B, and C to say what are generally accepted. Well, they're the requirements under the RAP rules, right? So under 2A, they're saying it's defined by the requirements of the RAP, the requirements of the Agency of Ag, Food and Markets, under controlled pesticides, and are you talking about prong C that says practices conducted and consistent with proper and accepted customs and standards followed by similar operators of agricultural activities in the state? Is that the one that you're kind of focused on? Because that's the one that has a little bit of flexibility, right? It sort of says, well, if you're doing things the way that others are doing them with accepted customary standards, then you're a generally accepted agricultural practice. I think that only gets a little squishy when you're talking about a new and innovative practice and you've got a farm implementing something that is, kind of new and innovative, and they were the first one doing it.
So,
That's
okay.
gonna be where it gets a little scratchy.
So your issue with prong B in the existing language right now is the good.
Yeah, it's an ambiguous term that isn't really helpful, right?
Yeah, but generally accepted is,
I think this is better because
Okay.
it's being defined at least. Could you make some changes that might make this a little bit better? Maybe, yeah.
okay.
Angela.
Thank you. Hello, Claudine. And would it, on that same line or those two lines, are we also back at the point where how would one prove that their agricultural activity is conducted in accordance with generally accepted agricultural practices? I mean, I know there's a definition, so maybe it's easier to check those boxes. But I wonder if it's still so broad that it wouldn't be enough to say, well, there is no regulatory action against my farming operation. Or would you have to set out some proof, I don't know, I think in some ways it gets us back to one of the questions you raised of like, you have to prove every required agricultural practice is being followed, or every requirement of the Agency of Agriculture for, you know what I mean? Like, are we at the same place? In terms of how to, that was lovely, but yeah.
So sorry.
Everybody wants a score, don't worry about it. I don't know if we could say something like, proof of the lack of regulatory
I
action.
think that's what subdivision or subsection B is putting the burden on the plaintiff to show that they
Okay,
were not in compliance with the generally accepted agricultural practice. Is that right? Am I reading that right?
Yes.
And that burden didn't exist before.
That burden did not exist before. They had to disprove.
yes.
To your point that you had to show all those things versus the plaintiff having to, okay,
Right.
that makes a lot of sense.
Yes.
Okay.
Yes.
So I did have one other question, and I'm not sure if I'm going to have the depth of knowledge to ask it very well, but I'm going to give it a shot anyway, since you're here. So for phosphorus going into lakes, and Lake Champlain and such, I understand there's some enforcement mechanisms, presumably that the Department of Agriculture has and such. Does this impact that?
I think I gotta say, I think that's a better question for Attorney Collier, because that's sort of right within his wheelhouse. I think he can
Yeah, no, fair
address
enough.
that. But I don't think so. I think the agency retains its regulatory activity here. This is just strictly addressing whether neighbors are able to bring those nuisance or trespass suits. I don't think this takes away any regulatory authority from the agency at all,
Yeah.
I mean, I think there has been I think it has been set forth that that we shouldn't leave it, that this essentially leaves it to the regulators, and we shouldn't leave it to the regulators because they disagree on some points, that there are places where the Agency of Ag disagrees with ANR and they can't get on the same page. And this has to do with the TMDLs and probably phosphorus that you're talking about. And so, gosh, we shouldn't leave it to the regulators, because if we do that, we are essentially cutting off the arms of neighbors who really should be able to come forward and bring these nuisance suits, because otherwise they're just effectively disarmed because the regulators are over there arguing amongst themselves. And I would submit that that's really a very inaccurate, it doesn't tell the whole story. I think you have to look behind the curtain to figure out what is this thing that they're arguing about, really, because you have to kind of understand that before you can make a determination as to whether this takes anything away from a neighbor that they should be able to have, because these folks over here can't get it together, right, allegedly, which is not the case. That my understanding, and again, I can be corrected by Attorney Colliers, is there's a dispute over whether tile drainage constitutes a point source discharge, and whether that should be through the delegation of EPA, these should be regulated in some way. And my understanding is A&R thinks it should be, and then the ag says it's not. And so I think we need to leave it to the regulators to have those conversations and to figure that out, and good minds can disagree on things, but I don't think that means in turn that we turn around and arm neighbors with a bazooka to be able to go after these farmers, because there's a legitimate conversation going on this end as to whose jurisdiction it is and whether these tile drains should be regulated as a point source or not. I don't think that should all of a sudden say, okay, well, now we could just let every neighbor sue a farm that's acting in conformance to the regulations under the Agency of Ag they've set forth all of these rules, and they're doing everything they think they need to be doing. But because there's this dispute over here, now all of a sudden you can just go ahead and have the right to sue them all and hold them up in court for years and charge them hundreds of thousands of dollars to be able to defend their farming operation that they're conducting in accordance with the rules that have been set out for them by a state agency. Gosh, that's a really confusing argument to me. It's very, very confusing that because there's a discussion going on this end, that all of a sudden we're empowering neighbors against farmers that are doing everything right, or at least think they're doing everything right. And if maybe they've made a mistake in some way, their buffer isn't big enough, well, that should be the Agency of Ag's water quality division that goes in and says, gosh, Mr. Farmer, your buffer is supposed to be 20 feet here, but it's really 15. I need you to add some more to this buffer to this field. Okay, oops, sorry, the mower went a little too far, and I acknowledge I got to do that, and I'll reseed that within 15 days, and off we go. That's the job of the regulators. That doesn't mean that we turn around and arm the neighbor with the opportunity to sue for nuisance and trespass. But what it means is that we have to make sure that those regulators have the ability to do what they need to do, which is to talk to the farmer and conduct their regular inspections and point things out. But I understand there is this dispute, but that's really what I understand the dispute to be.
So the nuisance or trespass in that situation is not that phosphorus is going into Lake Champlain. It's going over my property, but that may be a pretext for the fact that they're trying to keep phosphorus out of Lake Champlain. I mean, it's like they presumably wouldn't be standing for somebody just as a neighbor to sue somebody because phosphorus is going downriver to Lake Champlain.
Well, isn't that interesting? Because in this case, it was, right? The court issued an injunction in our case that said you can't send any water across our property and the contaminants that it carries. Now, I really don't know what that means, but it's been determined to mean like sediment that it can't, because I mean,
but that's the impact on their property, not downriver.
Yeah, well, that's what the judge said. And the judge said, if you can't stop it coming out of the tile drains, you got to stop all water that comes out of the town ditch that hits the culvert. Can you imagine that? So our client is being charged with stopping all the water that comes down the road from the town of Panton, miles of dirt road. And they have to stop all that water unless they can stop it all coming off of their 300 acres that's coming out of their tile drains. When the recent testing of that water, which I offered to the Senate committee and I'll offer it here too, came up completely clean, no suspended solids, the water was clean. And my client drank it out of like 7 or 8 of the 15 tile drains that we visited. Glass of water, and I brought those images. I'm happy to distribute those too. A clear glass of water, because it's effectively groundwater. right? It's water that's percolated through feet of soil. It's effectively groundwater. It tested clean. He drank the water. And so now we have to stop all of that water from 300 acres of land. And if we can't do it right at that source, we have to stop all the water off of 300 acres that then drained into these pre-existing drainages and then went through pre-existing town culverts and drained across pre-existing stream channels into Lake Champlain. We have to stop it all. It's impossible. It's absolutely impossible. But that is what we have been charged to do by the court.
And you'll send us that case.
I'm happy to do that. And I'm happy to send you those exhibits as well, to show you those. And I'm happy to send, I'm happy to share that court's injunction if you'd like to see that too.
Yeah, no, that'd be great.
It's frankly, from our perspective, it's mystifying, and it's been very problematic as to how we can accomplish this goal.
Appreciate it. So we're just gonna take 5 minutes so that we're fully awake and aware for Harold when you testify. So, run and grab some.